get this party started. Glad we were able to find this room. Some of our own folks went to this room or so. It worked out great. So, all right. Well, welcome back to Jefferson College, everybody. Appreciate your flexibility. I know we had to reschedule several of our sessions this year, but this was one worth making the effort to attend. Today we're going to talk about legal stuff, and you've got some handouts that we'll need to give as we go along. But just kind of let me frame the discussion here in 30 seconds or less, and just tell you that the real irony of the way administrative life has changed is that a lot of what we do now involves legal questions. And I think our second catchphrase after see if we have it in the budget is, let's call Kate. Because we do have to find that even on things that we feel pretty confident about, we want to make sure where we are. And unfortunately, Kate doesn't always give us the comfort we want, because she says, well, the law in that area is changing. And I have to believe it. And it always is. So we invited Kate Nash. She is the Jefferson College's legal counsel, but also is with Tuith Keeney. And there's another name in there somewhere.
There's three more names.
Three more names. Well, I'll call Tuith Keeney. They've been our attorney for a couple different areas, policy review, and then about 3 years ago they became our general counsel. And we just really thought it was important for you to get a sense or a flavor of some of the legal issues that we deal with, some of the things that are predominant in higher education. And I'm sure it'll spur some questions along the way. So you don't have to listen to me anymore. I'm going to turn it over to Kate Nash.
Hi everyone, I'm glad to be here, and I know I was scheduled to be here for another session and we had to reschedule, and that was because of me, so I apologize for that, and I'm thankful that all of you were able to come again today. As Ray said, there are a lot of legal issues related to higher education, and I actually have taught 6-hour sessions on this at some of the local institutions of higher education in St. Louis. But I wanted to focus our discussion on an issue that I think is particularly interesting, and also something that everyone in an institution touches on in some way, and those are really student issues. There are a lot of student issues that are legally related. And so, and I also thought that was important because that's really why all of you are here. That's why we have higher education. And I was looking at Jefferson College's mission before I came down, and our mission is quality education, student-centered, comprehensive, accessible. And I think that's what all missions of institutions of higher education are and should be, which are student-centered missions. And so while there are a lot of different things we could talk about, what we're going to focus on are some student issues today. So I wanted to actually just get a sense first of, I know we have a lot of different types of folks here today. I know we have HR people here. How many of you are in HR? Okay, then do we have finance office folks? Where are you all from? What kind of offices do you work in?
Admissions.
Admissions, okay. So you definitely deal with students.
I'm in arts and science.
Arts and
division chair.
Okay. Anyone else?
Student services.
Student services.
Faculty.
Faculty, okay. So all of these are obviously areas. I mean, pretty much every area in an institution deals with student issues to varying degrees. So what I thought I would go through are the legal issues that come up, starting even before a student gets accepted to an institution, and then kind of working through the issues that come up while the student is admitted here, and even after the student may leave the institution. And we're going to break up the discussion with some hypotheticals that I brought. And the hypotheticals actually all relate to real situations, either lawsuits that we've handled or calls I've gotten from institutions of higher education and how we handle them. And Ray is exactly right that one of the challenges dealing with these legal issues is that the law evolves. And part of that is a reflection of our society and the expectations that we have as a society about how institutions should treat their students, and the students' own expectations about how they should be treated. So the first issue to think about with students deal with admissions issues. And there's a big issue in higher ed right now that really doesn't impact community colleges, but it's something you might have seen in the news related to affirmative action. Has everyone heard about affirmative action issues? And so affirmative action comes up at large state institutions primarily because affirmative action challenges relate to the requirement that state institutions not discriminate against applicants on the basis of their national origin or their sex, their gender, but most importantly their race as it relates to affirmative action. And what we've seen are some large state institutions wanting to create a larger, more diverse student body have come up with ways to try to create racial diversity, the two notable ones being the University of Michigan and the University of Texas. And so we've seen challenges to those sort of race-conscious admission policies related to affirmative action, and really the courts have been striking them down. Now, that doesn't really affect community colleges because you all have open enrollment. And so you don't really have admission criteria in the same way that a state institution may have. But you also have issues that come up in your admissions that may affect your student body or decisions you have to make. One of those I know some institutions struggle with are the issues of students that have criminal backgrounds. So have any of you come across issues with students that have maybe a felony conviction and how have you, what kind of questions have come up in that context, or how have you dealt with those? Yes, ma'am.
Well, in the teacher ed program, in those courses, students have to have a clear background check to be able to go out and do their field experiences in the schools. And so we've had some issues in that area in terms of, who we deem to have passed and not passed.
Right, and actually that is the issue that comes up, is when you have programs that have certification or licensure requirements. And so I've gotten questions from institutions saying, should we even admit someone who we know isn't going to be able to be licensed or certified when they finish this program? Because is it fair to take someone's money and have them go through this entire program and then they can't even get a job in that field when they're done? And I think, and that's a challenge, and community colleges models have typically been to allow everyone in, it's open enrollment, and then you get to that end point and you think, uh-oh, what do we do now, because this person can't get certified? And a lot of times the student's really mad if they find that out, and they're really upset and they feel like they've been misled. And so that is something to think about, and I will say most institutions that I deal with, they've either adopted policies saying, this is the requirement, and so if you can't meet this requirement, you're not going to be able to get into this program, or they just notify students at the outset, these are the requirements you're going to have to be able to get certified after you finish this program, and if you can't meet them, you probably don't want to apply. And I actually had this come up in a different context. I did a presentation a few weeks ago to an organization that helps women transition from prison back into society, providing them housing and help getting employment. And as I was doing this presentation, they said, are there any laws that protect people that have a felony background or were convicted of crimes when they're applying for jobs or applying to schools? I said, you know what? There aren't a lot of legislatures or congressmen who view convicted felons as a group they're trying to protect. So there really aren't laws that protect those folks. And from this group's perspective, they thought, oh, this is so terrible. These people are trying to become productive members of society. And it was interesting to hear their perspective, because I'm used to thinking about it from the perspective of the institution that's frankly worried about the other folks that are going to be exposed to someone with a criminal background. But it was a good reminder, and I think community colleges are in a particularly sort of difficult position there, because you all are open to everyone. You're trying to help everyone improve their education and place in life. And so it's a question that comes up. So something there that I thought is interesting and really particular to you all. Okay, so when we get past admissions and we get into students who are admitted, and here, have you all heard of the term in loco parentis? Has anyone ever heard of that? Okay, so that's the phrase sort of in the place of parents. It's a Latin phrase meaning in the place of parents. And it used to be 30, 40 years ago, or actually longer than that now, that when students got to college, the expectation was, and this is more for residential type programs, that once the student got there, the college kind of took over and you were acting in the place of parents. And so you were trying to figure out how to help the student navigate situations, helping them with all those types of issues. And then that started to evolve over time, and students said, we're adults, we don't need you all to tell us what to do. We can help figure it out for ourselves. And so that relationship evolved. And again, going back to Ray's point about the law evolving, this is one of those areas where it did evolve, which is that expectation about the relationship between the student and the institution. It's shifting again. And I always think about the term helicopter parents, or part of the reason why it's shifting is that we have, and this has been going on for probably the last 10 years or more, we have a group of very involved parents who get really involved in the student's education and want to manage that. And so there's almost now a move towards a consumerism relationship between your students and the institutions because of the expectations those parents have and the expectations students have about how they're being treated. I had a situation at an institution about 3 weeks ago where a student was sending complaints to the faculty and to the provost and to everyone in the institution, and all of his emails were ending with the line, I paid for this, I'm the customer, I'm always right, you should do what I say, which made his faculty member really mad because the faculty said, this is not a service industry. He's not coming in here buying a product from me. I am an educator. I'm trying to teach him. And it created this huge tension between the faculty member where I had a faculty member and a student filing complaints against each other, and they were both really mad and agitated. And it took a great student services dean sitting down with the student saying, I want you to read what you wrote. And I want you to think about, and I want you to read it, and I want you to sit here and think about how that sounds to someone receiving this email. Because what it sounds like you're saying is pretty mean and pretty harsh, and this faculty member is pretty upset about it. But that just goes to demonstrate sort of the expectation and that changing relationship that we're seeing, and that all of you probably see in your interactions with students. I mean, how many of you have had a student walk up to you and say, I'm paying tuition to go here, you should do what I say? I mean, you just see that more and more, and it's incredibly frustrating. I just know that that's an issue that comes up. So we have that evolving relationship between students and institutions. And then an issue that also comes up with students do the students have formalized relationships with the institution, and what are the rights associated with those types of relationships? And so how many of you have heard the term at-will employment in Missouri? Okay, and then if you're not at will, what are you? You're a contract employee, right? Okay. So those distinctions, there isn't such thing as an at-will student, but there are such things as whether or not students have contractual rights. And students tend to say that there are either the policies of the institution create contractual rights either with regard to student discipline, or if you have housing on your campus, you probably have a housing contract students may sign. And there may be other places like tuition agreements that sort of set forth, what the relationship is between the student and the institution. And we're seeing more claims by students that, if you don't follow, that we're seeing more sort of breach of contract type claims by students where they're saying, you have held out, this is how you're going to treat me, if you don't treat me, I'm going to sue. And I will say something else that I've seen more of recently, which has been a surprise, is that more students are suing institutions. That used to really not happen that often, but we're seeing more and more lawsuits actually filed by students, which I think is an unfortunate trend. So that's on the issue of contracts. Okay, so on the other thing that comes up a lot with students relates to student activities. And this is also fraught with all kinds of peril, which is odd, but students engage in a lot of activities, organized activities on campus. One of those activities may be student association, student groups. So all of you have on your campuses a student code of conduct. And that code of conduct probably, hopefully, has language in it saying that students won't act in a discriminatory way, they won't harass other students, and if they do, they will be subject to some type of discipline. Well, an issue that comes up in the student association context is the right of students to associate with other people that are like-minded. And sometimes we see conflict between the beliefs of a group and how those beliefs may relate to characteristics of other individuals. And the place that this has come up in litigation is in the issue of student Christian organizations that don't believe in gay marriage or have beliefs that homosexuality is wrong, and then those rights of gay students on your campuses. And so there's actually been some litigation about this, and so our first hypothetical is going to get into that particular issue, but I just wanted to kind of frame that. And so hypothetical one, and I know the mineral state books or mineral area books don't have these yet, so I will say, okay, yeah, thank you. Try to go through every legal principle related to higher ed, but I do want to set this one out. How many of you all have heard of the First Amendment of our U.S. Constitution? All right, so our First Amendment of the U.S. Constitution is the amendment that says we have the freedom of speech, right, among other things. It also says we have a freedom to associate. Association with like-minded individuals is considered part and parcel of your First Amendment rights. So, and now as community colleges in the state of Missouri, community colleges are public entities that are subject to the First Amendment. So a student that goes to a private institution does not have quote-unquote First Amendment rights because private institutions aren't covered by the First Amendment. Public institutions are. So in this situation, we have a public institution that recognizes student organizations. And courts have said that part of students' First Amendment rights is to associate and share like-minded views with like-minded folks, and that there is a First Amendment right to be recognized by an institution because of the benefits that go along with that, such as getting to use space on campus, getting to use campus mail, getting to use campus email. So there is a First Amendment right fundamentally in that. We also have, as I mentioned before, on campuses, non-discrimination, non-harassment policies. So sometimes those two things conflict. And in this situation, this week we saw a conflict. So you all have had a chance to read this now. What do you all see? What are the two competing interests in this situation? I don't know anyone's name except for Tasha, so I'm going to keep calling them. And Ray.
Part of the academy.
I'll just start pointing at people then. I'm not afraid to call them people. I actually teach as well, so I do the Bueller thing sometimes, yes.
the citing the bylaws and a person's personal belief in their ability to have marriage relate to anyone, not just between a man and a woman.
Right, so we have an organization that in order to be a member of it, you have to sign into the statement of faith, basically saying that you don't believe in same-sex marriage, that if you don't do that, you can't be part of this organization. And then we have a student who says, well, wait, I'm gay, and so by who I am, I can't be part of this organization. I'm a student at this institution. There shouldn't be organizations to which I can't belong because of who I am. And you can also see this come up in a situation, thankfully, we haven't seen someone litigate this, but the same kind of thing could happen if you had a local student or affiliation of a Ku Klux Klan group. What if the Ku Klux Klan said, we're going to start a student organization on campus, and you have African American students saying, well, we can't join that if you're going to have a membership belief that, that says African Americans are less than whites or something like that. So you see this, you have this group that says, we believe something, we want to identify, and then you have a student that says, well, hey, wait a minute, what about my rights? So how do we balance these things? What do we do? What would you all say? And this is why you call the lawyer. No, I mean, these are hard questions. You've got two different groups of students who both believe they're right. And who is right? How do you decide? The institution has to make a decision. Somebody gets what they want, somebody doesn't get what they want. And the institution is making the decision about who gets what they want. And it's hard, and someone's going to be unhappy. So in this situation, who do you all think would win if a lawsuit was filed? Is the organization going to have the right to be recognized? Or is the institution going to be right in denying recognition to the organization because of the fear that their beliefs violate the non-discrimination clause at the institution?
Before you reach out to an answer, I'm going to make one observation, and that is, this is one of the hardest things from an administrative point to run into, because to answer this question, the first thing you have to do is you have to take your own beliefs out of this decision. Because you may find that you agree with one side or the other wholeheartedly because it matches your personal beliefs. But that's not the question. And so you first have to take your own beliefs, put them aside for a moment, and try to figure out Kate's question, which is, what would the law demand that you provide as an institution, rather than what is it that you personally think you ought to do? And it oftentimes is a very different kind of question.
And I would say it's a hard question for lawyers too. I mean, there is a law in Missouri that I'm not going to name that I very much disagree with. And when it first came out, I was talking to my law partner, former law partner, Tom Tuith, who is now semi-retired, and we were debating it, and I said, that can't be right. And Tom said to me, I know, Kate, what you want the law to be. We have to advise our clients about what the law is. So it's not easy for lawyers either. I mean, these are hard questions, and we have to put aside our personal views and say we have to give our clients the best advice about what the law would require so that if they do get a lawsuit or something, they're in the best position to defend themselves. So these are not easy questions. So having said all of that and putting aside all of our personal beliefs, who do you think should win in this situation? Does the organization get recognized or does it not get recognized? Not, okay. How many say not, the organization is not recognized?
I'm stepping back to the beginning or earlier some of the terminology when you said who's right and who should win. What's the definition of right versus legal or illegal?
And so when I'm asking that, well,
Right or legal or illegal,
you're right.
There's a difference.
Let's say you're right. That's a totally fair question. So from a legal perspective, and knowing that I know you all aren't lawyers, and just kind of thinking, what do you think what would a court do in this situation? Do you think a court would tell the university they have to recognize the student organization, or a court would tell a university they don't have to recognize the student organization? So we said, are you still saying not recognize?
Yeah.
Okay, so how many say the court would say you don't have to recognize the student organization?
This is just what we think the court would say.
Yeah, I know, right, we're not, okay, so, all right, how many people think the court would say you do have to recognize the student organizations? Well, you know what? You actually reflect what happened. Because what happened in this situation is the Christian Legal Society sued Southern Illinois University in Carbondale. And it was a similar case. Now, the University of Southern Illinois University did not have what we refer to as the all-comers policy. They just had a basic non-discrimination policy. And that Southern Illinois University said, you, Christian Legal Society, you violate our non-discrimination policy. The trial court agreed with the university and said, you don't have to recognize this organization. They appealed it to the Seventh Circuit Court of Appeals, which is the federal court that oversees Illinois, and the federal court, or the Court of Appeals reversed that and said, no, you do have to recognize it because those students' First Amendment rights overcome the individual's right under the non-discrimination policy. About the same time, Christian Legal Society also sued the University of California, Berkeley for the same reason. The Ninth Circuit came out in the opposite way and said, you don't have to recognize them, but the difference there was that the University of California, Berkeley had what they called an all-comers policy, saying that if you're going to be a recognized student organization, you have to agree to our non-discrimination policy. That was the only difference between the two cases. So then we had what we call a circuit split. Two different federal courts and two different jurisdictions had come to different conclusions. And so the case went up to the United States Supreme Court, but the case came up from California, not from Illinois. And so the facts before the US Supreme Court were the facts involving the all-comers policy. And the US Supreme Court upheld what the Ninth Circuit said and said, under these specific facts, when you have a policy that says all student organizations have to agree as a condition of funding that they will admit all students to their organization, under those facts, University of California, Berkeley, you have the right to not recognize the Christian Legal Society because they won't allow in a gay student. Now, if the case had come up from SIU, it probably would have gone the other way because SIU didn't have an all-comers policy. And that's how hard these things are. Courts actually disagree and reverse each other. And so it's very difficult for the rest of us not on the Supreme Court to sometimes know what the right thing to do is. But that's just one example of where these situations can come into, student interest can come into conflict. I'll tell you about another situation I had at a community college a couple of months ago. I got a call from a college president saying, Kate, we've got a student in our parking lot who's hung a Confederate flag from their truck. I just got a call from a black student saying that he's offended by the flag and he wants us to go tell the student to take the flag off his truck. The truck was parked in the school's parking lot. He said, what do we do? What do you guys think? Can we tell that student to take down the Confederate flag, and if so, on what basis?
Probably tell a student to do anything.
You what?
You can probably ultimately tell them to do about anything.
Why do you think that?
Well, and ultimately, while it's still public property, you can't openly, actually you can't do anything you want in America, really. At this point, you just hire you and you sue and all that. I mean, it's what it
She's very
is.
busy.
I mean, it's what it is, but
Well, so the issue is...
it's a matter of going out there, what's the intention? Is it to openly offend and so forth? And there's a lot more information we probably don't have behind why the student intentionally put a Confederate flag up and things of that nature. But, there's a whole lot of issues out there. Again, you can probably fall under non-discrimination where any student on campus is not supposed to go out there and openly discriminate against other students on campus and things of that nature. I mean, I can't, a student probably is not going to be allowed to just walk down the halls of Mineral Area College screaming the F word repeatedly either.
Right, so
Right?
you have raised a lot of
So-
different First Amendment issues. So the first issue that you bring up, that you kind of deal with is, is this speech protected? Is the speech the student engaging in protected? Tell you, walking down the hallway saying the F word, not protected speech.
Right.
Obscenity, not protected. So we can put that one aside. What if you had a student that had, you had two students parked next to each other, one that had a pro-life sticker on their bumper, one that had a pro-choice sticker on their bumper, and they both said, I want you to tell the other one to take their bumper sticker off their car while it's parked on college property. Would you all do that? No, you would not do that, because you would say, you all have the right to your own political beliefs. And we may not, everyone has a different opinion about that. We recognize it causes a lot of upset, but we recognize students have First Amendment rights when they're on our property, and we're not going to tell you what you can and can't say. So then the question becomes, as you raised, is a Confederate flag speech? Is that speech that's protected? Does that student have a right to hang a Confederate flag from their car? What do you guys think?
Yes.
Is that a yes? Yes. Yes, the Confederate flag, the First Amendment recognizes what is known as symbolic speech. And symbolic speech is something that is meant to convey a message. So if if a kid is just wearing like I was about to say something that was really going to date me, so I'm not going to say it. But if a kid is just wearing a T-shirt that has like a bunch of obscenities on it or something like that, there's no message that's meant to be conveyed by that. And so courts have said you have to intend to convey a message with your speech. And so you look at whether or not the speaker is trying to tell you something with the symbol. So in the case of a Confederate flag, frankly, it could be trying to convey something, or it could just be that this kid likes the pattern and likes the Dukes of Hazzard and doesn't really know what it means symbolically. And so if this kid is trying to convey a message, then that speech is protected because it's symbolic speech. And there was actually a college out of New York who was in the paper in the last year because they had a student flying a Confederate flag from their dorm window, and they got a lot of complaints. And the school initially went to this kid and said, you got to pull that out of your window. And the kid said, I am not trying to convey any type of hate speech. I'm conveying Southern pride. And courts have actually weighed in on the issue of what the Confederate flag means. And they have said it might mean racism, but it might mean that you're just trying to, show Southern pride. And so we're not going to say as a matter of law that the Confederate flag is always hate speech. It's going to depend on the message of the person trying to convey it. So in the situation we had at the community college, they said, well, can we get this kid to take down the flag saying that it's hate speech and it violates our non-discrimination policy? I said, no, because we don't know why that kid's flying the flag. Why don't you go talk to the kid and find out why he's hanging the flag from his car? So they had someone go and speak to the student, and the student actually said, I had no idea this was offensive. I will take it down. I did not mean to offend anyone. Which really surprised me, but it was a great result because the kid, it was a teachable moment. That kid learned another meaning of the Confederate flag that he actually did not know. And the student who complained about the Confederate flag hanging was also happy because it was no longer hanging in the parking lot. So those are the kinds of situations we see where sometimes things that seem so obvious to us, like the Confederate flag being offensive, sometimes it depends on the generation of student you're dealing with, and they may not know.
Okay, before you leave that, what if it were a faculty member's car or a staff member's car and it was in a clearly marked staff parking lot? Does that change anything?
Well, the rights of staff and the rights of students on the First Amendment issue are different. Students have more expansive rights on college campuses than faculty do, than staff do. And so if it were a staff member, it would be easier for you to go, because with staff, there's a different test. You're basically balancing the disruption that may be caused to the workplace by the speech the staff person's trying to engage in. And I think if the staff person was actually flying the flag and they were trying to convey, some type of hate bias, you could say to them, it's very disruptive to our school operations to have one of our staff people hanging something that might make you unapproachable to students of African American descent. Because if you're like in admissions and a black student sees you hanging a Confederate flag from your car, they probably aren't going to be comfortable talking to you. If you're our school counselor and you have a Confederate flag hanging from your car, our black students aren't going to come talk to you. And so that would give you, it would depend on the circumstances, but you would have more of a basis to ask the person to remove the flag than you would with a student.
And the same thing then, following the other analogies with dress code and things like that, that you can also talk to employees about, to some degree, how they might dress and how it might be inappropriate as a workplace environment, even though students might be allowed to dress.
In the work context, it's different because the test that you look at there is balancing the employer's legitimate interest in keeping a workplace that's moving forward and efficient, whereas for students, they have more expansive speech rights because you don't have that same interest. Now, the other thing to remember is when courts look at these speech issues, they're always cognizant of the fact that these are institutions of learning. And courts are always like, these are all opportunities for you to teach your students, and it's the marketplace of ideas. And so courts aren't afraid of there being controversy with student speech on campuses because that's why you're here. I mean, that's what they think. So, I think that's a fair point. I think there was another question, I don't know if you got it.
Oh, so let's say the faculty member or staff member refused to take the flag off of their car and they get fired for it. Would that be grounds for wrongful termination?
There are a lot of assumptions in that question, but let's
yeah, I know. I kind of went for, you can see where I'm getting at though.
So a lot of it really depends. I mean, there are a lot of other issues related to termination of public employees. And so there are a lot of stuff, Tasha can tell you that there are all kinds of steps you go through before you actually fire someone. Or, you just say you're gone, see you later. But it would really depend on the circumstances. And so what I would, if that happened, to me the first step would always be going to the staff member and saying, this is offending some of our, can you tell me why you're flying this? Is really offending some of our students, and trying to work it out informally. If the staff member said, I'm hanging this flag because I am a member of the Ku Klux Klan and I want everyone to know what my beliefs are. In that case, you would move forward and you would document and say, this is a violation of this, this, and this, and you would just try to figure out, and you would go through your process. And in that case, you know, the employer would have a legitimate interest in maintaining the workplace and making it an environment where students were comfortable and where they could come to the staff. And I think there you would have, you know, a lot of defensible positions. Now, can they file a claim alleging discrimination on the basis of the First Amendment? Of course. You know, we've already had the observation, anyone can file a lawsuit for any reason. The question becomes, is there a defense that the institution has that's good and that explains the termination and that it doesn't violate that person's rights? So there's a lot of different things could change the outcome of that, but there certainly are outcomes that would be defensible and appropriate. Any other questions on that?
How does culture play into some of this? Because you look at states like South Carolina and other places where the Confederate flag is still a component of their state flag. I mean, this is one example, but culturally different parts of the country, California versus Illinois. I mean, I think, you know, a lot of people would draw a conclusion that Berkeley's maybe a little more to the left of center of America than, say, Southern Illinois and Carbondale. I mean, culturally, this plays into these decisions legally and otherwise.
Absolutely, and so that, when I talked about before how the courts have said that the Confederate flag does not symbolize, there is not a law that says this symbolizes, you know, discrimination, and that's for that very reason, that culturally we all bring our own readings into these symbols, and so courts are interested in, when you have the symbolic speech, they are interested in looking at what culturally do people view that speech to be? What message are you trying to convey? And that's going to totally depend on the culture. So there are symbols, and I can't think of one at the moment, but there are symbols that have changed over time. And I think the Confederate flag actually is a good example of one that has changed over time. But absolutely culture plays into that, and it relates to the issue of what message are you trying to convey with the symbol? Or what message, you know, what is the sort of the norm at that time, and might that violate your non-discrimination policy or non-harassment policy or not? I mean, it just really, it totally is, it does depend a lot on culture and evolving society, absolutely. And one other issue that that relates to this sort of student organization issue that I've had come up before that also relates to this cultural issue. I had a community college, actually it's been several years now, where a student organization, a student group wanted to have an officially recognized organization for the organization NORML, which is an organization that advocates for the legalization of marijuana. And it went up through, and there were people, actually the student senate initially denied them recognition and said, well, we don't want, you know, a marijuana leaf flying underneath our college's logo. That's crazy. And it actually went up to administration, and administration had to go back to the student senate and say, you all don't get to decide the type of speech, you know, that you think is appropriate. This organization has legitimately filed their application, they meet all of our criteria. Just because you don't like what they're saying doesn't mean that we don't get to recognize them. And it caused a lot of consternation. People were upset about that because they said, well, we don't think it's appropriate for a student organization to be advocating for the legalization of marijuana. And that was another situation where, as Ray said before, you know, people had to put aside their personal beliefs and recognize that these students had the right to engage in this type of speech and that the institution was going to recognize the organization. But that's another one where they're sort of changing cultural mores on those issues. And the difference there is these students weren't, you know, they were advocating for a change in the law. They weren't advocating for people to break the law. And if you're, you know, students don't have the right to come on campus and say, you know, burn down the administration building. I mean, that's disruptive speech that could cause a problem.
That's a faculty staff job.
Yeah. But students do have the right, and other people have the right to come on and say, we don't like how this is happening, we think it should change. And they have, I mean, that's what we're about in this country, is advocating for change. And you know, and people have the First Amendment right to do that, including students. So that that's the issue. So that's sort of dealing with the student association rights. Okay, so now I'm actually going to shift gears and talk about another law that we're seeing a lot of information about in the media, and that is Title IX. How many of you have seen something about Title IX in the media recently? What kind of issues have you all seen about Title IX, or what are you familiar with? What is Title IX?
Sexual harassment is what I think of.
Okay.
Gender equality.
Gender equality. And how does that play out? Gender equality in what way? What is
You
that?
hear more sports, like especially with the offering of scholarships. If you offer so many scholarships to football students, you have to compensate by offering so many scholarships to female sports is usually where I hear about issues.
Okay, and then I heard sexual harassment. And so how many, so when you all hear Title IX, what about others in the group, what do you associate Title IX with?
I think I heard an example of some
students being down at the pool, and some boy students were making comments about how beautiful the girl students were, and beautiful is probably the loose term. And I think someone overheard it, and it became, I think, a Title IX concern.
So sort of the sexual harassment issue again, okay. How about other things you've seen in the news maybe about Title IX? I'm throwing out anyone see anything in the news recently about Title IX? Anyone know what I'm talking about? Title IX, Mizzou, Florida State University.
The rape stuff.
The rape stuff, sexual assault.
How you turn it, report it.
Yeah, that's exactly right. So Title IX is a provision of the Education Amendment Act, and it was passed in 1972. And it's a very short statute. It basically says that institutions that receive federal funds cannot discriminate on the basis of gender in any of their programs, their admissions, basically anything. And it's actually a law that has evolved over time. So initially it was if your particular unit at an institution received Title IV funding, student financial aid funding, that particular unit can discriminate. And it's basically now, it's just sort of the entire institution can't discriminate on the basis of gender. And it comes into play in a lot of different and sometimes unexpected ways. So what most people, I would say, prior to maybe 3 years ago, when you said Title IX, almost everyone would say sports, because that's sort of where the play was in Title IX. It was this issue of equality between sports teams on campuses, and you actually still see in the news, so this so-and-so has to cut their program, has to cut their men's track program because they have to have equal funding. And actually there was just a decision in the last month in the K-12 context where a high school had used boosters to raise monies for a new football stadium, and the Office of Civil Rights has said that money counts towards your Title IX requirements, and so you have to tear down your football stadium because the funding inequalities it creates with your female sports, which is just crazy, and hopefully that will get overturned. But it's this, we still see a lot of action on the sports side of it.
And it's not all women going to men's, inequality in that regard, but there's a case in St. Louis, in Eureka or somewhere, where there's a boy who wants to play on the lacrosse team. There isn't a men's lacrosse team.
Yeah.
So he's suing under Title IX,
Yep.
saying that you're not offering me an opportunity, that you're offering other people. And so you started to see a reverse
Yep.
opportunity. And a lot of those men's track teams you talk about are turning around and counter-suing on Title IX, saying now we're discriminated against because in many large-scale institutions, university levels, there's more women's sports than men's sports. But it's a function because of football is so
Right.
gigantic as far as dollars and figures, and so they have to do that
Yep.
to keep it equal.
And that's exactly right. And so what Title IX prohibits is gender discrimination. It does not matter what your gender is. It protects men the same way it protects women. When it was passed, certainly the idea was that it was going to create more equality for women, but it's a gender discrimination statute, and it also protects men in the exact way that you talked about. And it's interesting because we see, I think it's being used in ways like the example you gave with the guy who wants to be on the lacrosse team, in ways that it probably wasn't contemplated to be used. But when you read the statute and it says, don't discriminate on the basis of gender, and the student says, I want to have an opportunity to play lacrosse, courts suddenly say, hey, you know what? That's an interesting question. How is that? What are we going to do with that situation? So it started as really a statute dealing with, or it was really used initially as a statute dealing with sports. It also was used to integrate a lot of single-sex institutions back in the 70s and 80s. And there is an exception to Title IX. So the reason that we still have single-sex institutions of higher education is that there's an exception to Title IX that says if you are a private institution, you can have a single-sex undergraduate program, but it can only be your undergraduate program. So a lot of like the Seven Sisters, a lot of these institutions that have traditionally been females, you will see that they have, if they've gone sort of having online graduate programs or other graduate programs, those are not single-sex programs because they can't have single-sex graduate programs under Title IX. But there's still, Title IX does have an exception for only private institutions in that regard. Now, the current issue that's really getting a lot of attention under Title IX is this issue of sexual harassment, and more specifically, sexual misconduct and sexual assault. And that all sort of came to a head, and there was a lot of attention paid to it because in 2011, there's a federal agency called the Department of Education, which many of you may be familiar with in your jobs and your roles. And they have an office called the Office of Civil Rights, and that office is charged with the enforcement of the non-discrimination statutes. The Office of Civil Rights issues informal guidance to institutions that they call Dear Colleague letters. We refer to them as DCLs. How many of you are familiar with OCR? Yeah. So in 2011, the OCR issued, on April 4th, 2011, the OCR issued one of these Dear Colleague letters on the issue of sexual assault. And they said, we just want to remind everybody that we view sexual assault as sexual harassment, and sexual harassment is prohibited by Title IX. And this letter went into great detail about all of the requirements and all of the obligations that institutions have in the view of the OCR with regard to sexual assault on college campuses. And it included things as specific as, we expect you all to have completed an investigation of sexual assault within 60 days of when it's first brought to your attention. We expect that from start to finish, it is done in 60 days. We expect you to adopt preponderance of evidence standards in your student discipline conduct codes related to adjudicating issues of sexual assault. We expect you to have a Title IX coordinator who is looking at all aspects of Title IX compliance on your entire campus. And it went through and detailed a lot of these very specifics, and they were basically telling everyone, when we come to your campuses to investigate, if you don't check these boxes, we are going to find you to have been in violation. So in conjunction with that, we also saw a groundswell of student organizations across the country coming together and saying, sexual assault is a huge issue on college campuses, and we don't think you're handling it correctly. And there was a lot of media attention paid to this because these student groups, and I actually noticed you guys are having a Take Back the Night event tonight, hopefully, if the weather holds. But it's sort of that in that same mode of these students coming together and saying sexual assault is a huge issue. We think that college campuses are sweeping it under the rug, and we expect there to be action. I saw a lot of complaints filed against very large institutions with a lot of name recognition. University of Connecticut was named there. I think Oberlin had one. There were several institutions in California. And so all of these institutions were suddenly responding to investigations by the Office of Civil Rights, and those are actually ongoing issues. So then we had that happen in April of 2011. A year later, Congress passed a law called the Campus Save Act, and it actually made a lot of the requirements in the DCL part of statutory law. And then that went into effect March 1st of 2014. So, I'm sorry, 2013 is when it was passed, 2014 is when it went into effect. And so a lot of these requirements are now actually part of the laws that govern us under the Clery Act. We've now made those actual requirements. So what ends up happening with sexual assault issues is, even if you're doing everything right under the law, if you're not kind of doing things in a way that people would understand in the lay world, you're going to end up on the front page of the New York Times or of local media as sort of not doing things correctly, and it's very hard to respond to that. So a couple of weeks ago, we saw the report, how many of you have heard about the situation at Mizzou involving, so we had a very, very sad situation. A student, a swimmer, had dropped out of Mizzou, later committed suicide, but had alleged at some point that she had been raped by a football player while she was still at Mizzou. And what ended up happening is Mizzou didn't investigate it at the time. It became the subject of an ESPN investigation, and really the university is getting raked over the coals. They hired an independent counsel to go investigate the response to it, and that independent counsel issued a report a couple of weeks ago, and their conclusion was essentially that the university didn't investigate it properly, that the issue didn't come to the attention of the Title IX coordinator to do the investigation. And so it really kind of talked about, how we really need within our institutions for everyone to be able to communicate internally and for everyone to know who to go to when you have those concerns brought to your attention. And then even more recently, there was a cover story in the New York Times about Florida State University. I don't know if anyone saw that. This was a situation, and I will admit, I am not a college football fan, and so I think if you are a college football fan, the football player's name who was alleged, I would probably remember it, but I don't because, as I said, okay, thank you. We have a football college fan, or we have someone who actually knows football players. So it was a situation where a young woman alleged that she had been at a bar off campus, that she had been given something in a drink, and that she was then taken by a couple of men in a cab to someone's home, and that she was raped. And she then later identified the individual who raped her as James Winston. So, and she alleged that she notified the institution of the alleged rape, and that really there was no response to it. And this was all happening at a time sort of during football season, and this guy, I think he won the Heisman Trophy. Yeah, so he was a very high-profile football player, and so now the New York Times did an investigation and wrote an entire cover story about sort of the university's lack of response and how that was handled. The university, of course, is saying, you know, this isn't a fair portrayal, and we're not able to kind of talk about what happened because of FERPA and other issues, but this really isn't fair. But they really can't respond very well, and now there's a cover story in the New York Times about what they've done wrong, and it certainly, if you read it, looks really bad. I mean, who knows where the truth lies, but it's certainly not a good situation.
They claim they turned it over to the local police.
Right, and then they
Local police did not follow up or investigate, and so on and so forth.
Well, they do that. The article actually goes through and looks at what the independent investigator, or what the investigator from the police department did. And it sort of says it took him this long to call this person, it took him this long. And so it's really critical of the police department. And the police department gets no help from the local prosecutor's office, who says, I don't know why this took so long. I didn't have enough evidence to indict this kid, but it certainly sounds like something bad happened. So it was sort of critical all around. And we're actually seeing those kinds of issues come up. I know you're going to be really happy you have a police department now, Ray, but we're seeing in these situations criticisms of both police departments as well as the institutions. A couple of years ago, after the Dear Colleague letter came out, the University of Montana has been undergoing a long-term investigation about their handling of sexual assault. At the same time, the police department in Missoula, Montana was also the subject of a Department of Justice investigation about how they were handling allegations of rape and assault. And both ended up having to enter into resolution agreements with the federal government about how they would handle issues of sexual assault. So it's sort of a double press against both police departments and against institutions. So yeah, you got it both now.
Thanks for that advice now. But one of the
The
other
law is
aspects-
evolving, the law is evolving.
That's right, and you keep saying that. The other thing that's in both those cases you're talking about also raises the question of institutional responsibility beyond the campus limits.
Right.
Because, you know, both cases occurred off campus, or at least not on the instructional part of campus, but the institution is deemed to have some responsibility of and for these students, both in terms of investigating and protecting their rights, even though, and the last one, the football player, the Heisman Trophy winner, his case, he wasn't on campus at all.
They were in a bar.
They were in a bar off campus. How can that be the institution's responsibility?
Well, is he a greater responsibility though, because he's a scholarship athlete?
Well, that's the question. You know, does that give you that 24/7 responsibility for somebody even when they're off campus? And we have to report for a Clery Act, you know, things that don't even necessarily happen on campus if it involves, you know, personnel, key people, or we were somehow deemed to be involved. So the limit, the idea of what constitutes a campus has changed. And again, you know, coming under scrutiny, because in the Mizzou case, that was reported, that was an off-campus event too.
Yeah, it was also off campus. And I'll get to your question in just a second, but to go to that, OCR's view is that these sexual assaults, even if they happen, and I think this is true, even if they happen off campus, are going to impact the student's education on campus, because that student is going to be traumatized, or maybe that student, you know, we see situations where rapes occur off campus, and then you have members of, you know, if it's an athletic team, members of that team are kind of bullying or trying to, or, you know, following that kid, that other student on campus. So there can be follow-on from the actual assault itself that may come on to your campus, and that's really what OCR is wanting you to look at. And I'll tell you on the issue of a scholar athlete, an institution has a greater ability to do something about it, because for public institutions, you know, students have due process rights. And I mean, all institutions have codes of conduct that set forth the way discipline has to occur. But on public institutions, they actually are constitutional due process rights. And so you are more limited in what you can do to expel a student from your educational program than you are in your ability to take away rights like the right to compete on a football team. We can take away scholarships. There are other things you can do short of expulsion that you have a greater ability to do with an athlete than you do with just someone who's enrolled in your college. But yes, you had a question?
I understood that the difference was more about the fact that personnel at your institution were notified of it. So as soon as a personnel from the campus knows of the situation, that's when it becomes a responsibility no matter where it takes place.
Well,
if it's something where it's written in the paper or
No or should have known. The law often says should have known.
Right.
So,
So the
so a
president
notification in the
calls
paper then becomes a question, is it reasonable that you should have known because it was published? And I'm not sure the rules are always clear on that.
No, and let me just make a distinction here about how this all fits together. So why is it our responsibility under Title IX if it happens off campus? Why do you have to notify those folks if you knew or should have known? And OCR's reasoning is it's our responsibility because effects from that off-campus assault can affect your campus environment. But you're exactly right that, so then what that says is the test that then they put in place is if your folks knew or should have known, you need to tell your Title IX coordinator so that they can decide whether or not we're seeing those impacts on campus and do the appropriate investigation so that we can respond. And the OCR said there are a lot of different ways that we can respond. It may not be the initiation of some type of discipline action against the alleged assault. It may be that what we're doing is providing support to the victim. So it may just be that we're saying, you know, you really need some counseling, and so we want to make sure that you're going to our college counseling services, or we need to talk to you about, you know, if you have residential housing on your campus and you're in the same dorm as the alleged assault, maybe we need to talk about where you're going to feel safe or what we're going to do with your housing, or, you know, it's those kinds of things. So it's not, the response isn't always going to be disciplinary in nature, because you may not be able to discipline the student who did the assault, but what you may be able to do is support the student who's the victim of the assault, and that's what OCR wants you to do. So actually, our next hypothetical actually deals with a call that I got dealing with a campus assault issue. So if we can just take a couple of minutes. You know what, I skipped through. We're skipping from the student worker. It's the one that says sexual assault on campus. So we jump to that one. Why don't we go ahead and talk about this hypothetical. First of all, I will tell you that when we get these calls about sexual assault, they're some of the most terrible calls to receive, and it's sort of some of the worst situations institutions deal with. And they are always messy. It is never clear cut, and there are always shades of gray. When I got this particular call, the dean that called me just said, "I'm ready to kill this kid." He's like, and I said, "Wait a minute, we don't know what happened." And this kid, the kid who is the alleged assailant, he has rights too, right? We have to think about that, and that goes to the point you raised earlier. Title IX protects against gender discrimination for both men and for women. And so if we're just always making the assumption that the men are up to no good, that's a violation of those men's rights. So we can't make that assumption. We have processes in place for the purpose of adjudicating the rights of all these folks, and we have to follow our processes. So in this particular situation, the other fact that's not in here is that Sally is white and Adam is black, which added another level of complexity to this, because anytime we started to do something, Adam said it was race discrimination. So it made it very complicated. So what do you all think are the important, what are kind of some of the issues of concerns you see in this fact pattern that are kind of, how would you start working through this?
First thing I see is that she's now wanting to forget it, but now someone on campus already knows about it, so it's too late. It can't be forgotten.
So she says she wants to forget it. If someone else had come forward and she says, "I want to forget it," would you just stop everything? Okay, so what about her saying, "I just want to forget it," how does that play into it, do you think?
I think it goes back to our other cases. Someone on campus already knows about it. You're employed by the college, you have to follow through. You have to notify your title coordinator, so.
Okay. All right, so yes,
That's a large thing I see.
okay, what else is in here that might, is sort of something we have to think about as we work through it? So what do we do? I mean, so if there's nothing else in here that's questionable. Harassment, okay. I mean, what do we do in this situation? What would you all do if you were talking to the dean and the dean kind of went through these facts with you, or your VP of Student Services said, "This is what I got, what do I do now?" What would you do? Yeah.
Well, I think it's complicated by the fact that there's apparently 2 other students, but because of the counseling department not being able to give the names, you can't really get them to your investigation.
Well, should we just go to the counseling department and say, "You have to tell me who they are"?
No.
Okay. Why not?
They probably don't have to.
But is it a need to know? I don't know. It's counseling usually know, but.
Verb is probably floating around in there somewhere.
Purpose floating around and everything. Yeah.
It's like everywhere, so it's probably floating around in there somewhere.
So we know there's this obligation that when folks on your campus know or should have known, they need to notify your Title IX coordinator. You can have confidential reporting people on your campus who don't have that obligation to report it up. And the only people those can be are people who really truly have sort of a recognized confidential relationship with students. So if it's a religious institution, you have like ministers on campus, they would not be required to notify the Title IX coordinator. And counselors are those other people who have a therapeutic relationship with the individual. They also aren't subject to that sort of know or should have known reporting requirement. But there can be exceptions to that don't really relate to Title IX, that relate to the law of those relationships generally, that if you know that someone poses a direct threat, there may be times where that counselor confidentiality is overcome by a more immediate concern about safety, and those counselors then need to know. This particular situation, probably we don't have that because there isn't, that's more of like, you know, you have a counselor hears from a student, I'm going to kill this person. I have a gun, I'm going to walk over to someone's office and shoot them. Those are situations where the counselor wouldn't say, well, I'm his therapist, so I just thought I wouldn't tell anyone. Those are situations where the counselor would have an affirmative obligation to do something about it. But short of that, most of the time, those relationships are going to remain confidential. So we really can't now go to that counselor and say, I really need to know this for my student discipline proceeding. Tell me those names. So that certainly makes it difficult. What do we think about the fact that Sally was intoxicated during the alleged sexual assault? Does that matter?
Well, this woman used to live in Steubenville, Ohio, where the high school case 2 years ago, and cost several young people several years of their lives, and several teachers and coaches their jobs. The ability to give consent is always in question.
That's right. Yeah.
She said she was intoxicated. Adam said that she gave consent. So did Adam ever say whether she was intoxicated?
President, he didn't
He
believe
said she wasn't. He said she wasn't.
Yeah, he denies it. She
was drunk or otherwise under the influence.
So we
And
don't
then
know the answer.
Well, and then in her don't do anything, I think she said, well, maybe I wasn't.
She's trying to back out of the situation as quick as
Right.
you can, because the ball's going downhill too fast.
Well, is it because she's not credible, or is it because she's being pressured by members of the football team? I mean, it is uncomfortable to be a freshman making an allegation against a football player. That's just a fact of life, folks. I mean, I think we all know that. So here, is she backing down because she wasn't honest initially, or is she backing down because she's scared? How do we know, right? I mean, those are the issues that you're weighing. You're trying to figure out who's telling the truth. Somebody's not, because we have very different stories we're getting here. So to Ray's point, the issue of being under the influence of alcohol or drugs, for that matter, one of the things that the DCL told us was that colleges and universities need to take the stand that you cannot give consent if you are intoxicated. So if you are intoxicated, and if you know the other individual is intoxicated, that person is unable to give consent. Now, I will tell you, in reality, how does that work? What if you have, I had someone ask me once, what if I've got 2 drunk kids? Is it whoever makes the complaint first? I mean, who says it was sexual assault first? And that's a good question. I mean, it is a hard thing to figure out. And so part of what the DCL is meant to do, and part of the process institutions are supposed to be going through, is educating your students about these issues and saying, if you want to protect yourself both from being a victim of sexual assault and from being accused of engaging in sexual assault, you need to think very carefully about intoxication, because you may end up being raped or you may end up being accused of rape. And the only one who can control that is you and the way you conduct yourself. And that's part of this education we're supposed to be doing for our students. And I know those initiatives have been going on for a long time with mixed results, but we have to keep trying. And your efforts, like your effort tonight, are when you're trying to educate your students about making themselves safe. So that's an issue here. Now, as a practical matter, while we would say that being under the influence of alcohol would make her unable to consent if in fact a sexual assault occurred, it creates another problem for us in the student discipline context, which is if you go through a student disciplinary process, she can't testify to anything. She doesn't know what happened. And so what evidence are you going to be giving your hearing board about the assault? It's going to be the evidence of, I went to a party, I got really drunk, I woke up in some guy's bedroom, and this is what was happening. That's all she can say. And so now we're in a situation where if we're going to pursue student discipline, we've got to find other witnesses. We've got to find people who saw her at the party, who can talk about her going up to his room? Was she drunk when she was going up to the room? What did other people observe? When was the last time we saw her in the party? What time was that? When was the next time we saw her? I will tell you, most of the time, unfortunately, when these assaults happen, these students don't go to the ER. They go back to their dorm room and they take a shower, and there's no physical evidence of there being an assault. And also part of what we're supposed to be doing with our students under the DCL and now under the SAVE Act requirements is educating our students about what they should do to preserve evidence if they're the victim of an assault. And that should be part of your notifications that go to students as part of your Clery Act requirements and as part of your policies. So in this situation, so we've got an issue of how are we going to discipline her. Now, what about this issue of Nancy, of the girlfriend? What do we do with that? How does that play into this?
Try to connect with counseling and getting support services to talk about the relationship and potential abuse.
Yep, yeah, I mean, the other thing that happened as part of the SAVE Act requirements that went into effect in March is there are now requirements under the Clery Act for responding to domestic violence and relationship abuse that are also considered, those are also sort of related to Title IX. So in this situation, we have a sexual assault issue and we have a relationship abuse issue. And so we need to be talking to Nancy about providing her, we may not be able to proceed on a disciplinary front, but we need to figure out what kind of support we can offer to Nancy on maybe a counseling. Maybe we need to think about, should we think about different housing situations if they're living in the same residential hall? But those are all the kinds of things that need to be on our mind as we think about this. So what do you all think happened in this particular situation? Do you think, was there discipline against Adam? Did Adam survive this? Did nothing happen to Adam? Was there a disciplinary proceeding?
Maybe from a coach or something. I don't think the larger institution was able to do much.
Okay. Anybody else?
You could refer him, couldn't you?
You could what?
Counseling, refer him at least as part of, since he's under scholarship, you could require him to undergo certain steps.
Would you all have recommended proceeding through your disciplinary process based on the evidence we had about the sexual assault? And knowing that the student who was the alleged victim of the assault said she wanted everyone to drop it?
I go to Panhellenic.
You what?
Go to Panhellenic Council for the fraternity party.
Mm-hmm. Anybody else? So what actually happened in the situation is it was referred to, the assault was referred to their student discipline sort of process. That process ultimately determined that there wasn't enough evidence to establish a sexual assault, but they did refer Adam to counseling and sort of educational issues related to domestic violence and assault. And then halfway through the semester, we got a couple more reports of people coming forward saying that he had engaged in sexual assault against them. And while we were in the process of all of this, Adam started claiming that it was all race discrimination and that we wouldn't have proceeded against a white male who had the same allegations against him. And then we went out. They went out on break over the holidays, and when they came back, Adam brought a gun with him to school, and we booted him. And then he filed a race complaint with the Office of Civil Rights. And he ended up transferring to another school, and we had to kind of figure out what information we would give to that school and how that would be handled. And I'll tell you, on the gun issue, it wasn't as clear cut as it sounds. It was a family heirloom that his father had given him for Christmas, and he said that he was just bringing it to, it was something his father had given him. He would just bring it back. And that was one of those where we kind of picked our battle and we said, don't care, you've got a gun. We have a policy that says you do not bring guns into our residence halls. We're not messing around with this anymore. And it was a private institution, so we had more of an ability. We didn't have to go through the same process. We deemed him to be a threat, and we booted him out on that basis. But it was one of those where it was, we just kept hearing all this chatter, and it was incredibly frustrating because my dean was convinced that he was engaging in sexual assault, but we just couldn't get the students to testify at the hearings because it was scary. I mean, he was on the football team, and it was a small campus, and people were hearing about it, and it was a really difficult situation. But this one I really wanted to. I think when people hear about sexual assault, if you haven't had firsthand experience with it, it sometimes sounds like it's relatively cut and dry. Well, of course you should do this. Well, of course, And these questions are very difficult because there's almost always alcohol involved. Yes?
What was your holdup about what you could tell the school he transferred to? Like, was this considered confidential because it had to do with disciplinary action, or was it ethical, or should you pass it along to the other institution?
Well, first of all, we hadn't been able to prove anything.
Okay.
He had gone through a student discipline process which had adjudicated him as not guilty.
So just not passing along hearsay?
Right, I mean, it's sort of, what can you say, because we'd be defaming him, you know, if we would just be saying, hey, you know, we think this guy's sexually assaulting people, have fun with that. You know, I mean, it's sort of, it's not.
I'm not saying I thought you should.
No, right, but it was really, and at the same time, the institution was saying, we don't want to have him go somewhere else and do the same, you know, we don't want to put anyone else in danger, but we couldn't prove that he had done anything. And the other part of this is this student did go to the police. The student who was the alleged victim of the sexual assault had gone to the police at one point because her parents wanted her to go, but she wouldn't tell the police anything. They weren't able to prosecute. Sort of nothing was happening. There was nothing that was public or that had been decided that you could share. So, you know, under his discipline records, if there had been discipline, we would have been able to share that under FERPA. But all of the rest of this was, we don't know. We don't know what's happened. And maybe he didn't do it. We don't know. So, and that was very hard. And that was actually when I got the call initially, before this sort of played out, I got this call saying, this guy's raping people. And I said, whoa, we don't know that yet. Do you know that? Do you know what happened? And he said, you know what, I don't. And so we went through the process, and it kind of played out the way it did. But these situations are very, very difficult.
Your counseling point earlier about not having to relinquish, that's one of the other things that, you know, has been an issue in Columbia with the swimming incident, is that, you know, so the counselors basically said that individual came in for counseling, but didn't necessarily say, you know, didn't advise me that I could go on to say anything else. I mean, that's been one of the issues in there that's come out, in, you know, in a more public forum with that whole activity, is that public emotion that, well, you should, somebody told you they were assaulted, you should have done that. And that has kind of been a little bit of an issue that's played out in the public forum, is that, you know, there are privileges, and to some degree that person doesn't have to go forward and say, the student just said that they were sexually assaulted or what have you. They came in for counseling related to, but not necessarily telling me that I was free to do something with that information either.
And that's right, and the SAVE Act, that, as I said, went into effect on March 1st. Part of the requirements of that are that when a student comes to you, in whatever capacity you are, you're supposed to provide them written information about the resources and options available to them. The idea being, in that counseling situation, the counselor is at least advising the student as to what their rights are. Because I think in the past, a lot of counselors would have thought, I'm just providing sort of counseling services, and the student may later say, nobody told me, I didn't know what I was supposed to do.
And
so
that's
now,
what the student's family is ultimately saying, because that incident happened almost 3 years ago now.
Right.
You know, that's the question, but that's kind of their point, is like, you should have, part of your counseling should have been to help shepherd them in the right direction, because again, like you mentioned earlier, you're the parent now, because we're not there.
yeah, and I think, and this all goes to that evolving issue of the relationship between the student and the institution. And unfortunately, all of these situations are always going to be judged in retrospect. Like Mizzou, 3 years ago, I bet there were very few institutions that were sort of engaged doing the types of activities that this report or that the press looks at Mizzou and says they should be doing now. But all of these situations are always judged with the, in hindsight, 2020 hindsight. And so we can look, it's easy for us to look back now and say counselors or parents to say you should have done this 3 years ago. And so all we can ever do is think about what should we be doing now and do that on a going forward basis. But unfortunately, we're always going to be judged in light of what could have happened, and that's very difficult. Yeah.
Did their ages play a role? Because if she was a freshman, I would assume that she wouldn't be legal to be drinking, whether she was or not at a party. Like, did that have any aspect on any of the disciplinary action if they were minors or not?
That is a great question, and that is another thing that's addressed in the DCL actually. It didn't, in this situation, it did not play a role, but one of the issues that the DCL also addresses and advises institutions is that as part of your policies, you should tell students that they shouldn't be afraid to come forward for fear that they may get an alcohol violation, because it's more important to encourage reporting of sexual assault than to catch a minor who may be drinking. And that actually is a point they make, is some 18-year-olds may be reluctant to report an assault if they were intoxicated for fear that they were going to get hit with some type of drinking violation.
Or their witnesses, I would think.
Yeah, exactly. And so the policies that that you see coming out now all have like a sense or two that say your safety is the most important thing. You will not be subject to discipline for drinking violations if you report a sexual assault or a part of a proceeding. But that's a great question. Students certainly are reluctant for that reason to come forward sometimes. And I would say we had another sexual assault just a couple months ago at an institution, and it literally ended up involving, it was at a house that members of an athletic team were living in, and in 20 or 30 people ended up being interviewed as part of the investigation because it was another situation where a woman passed out, and we ended up, the investigation ended up interviewing all of the people who were at that party and kind of putting together a chronology of the night's events to figure out where she was at various points in the night, because the student couldn't remember, the victim couldn't remember, and the guy just wasn't talking. And so we finally had to say, well, we know at this time you were here, at this time you were here. And it turned out, by doing the investigation, another student had videoed part of the assault on his phone. And so it was a private institution, and so we had a greater ability to do a search and get that information. At a public institution, that's much more difficult, but you never know what you're going to find when you do these investigations. So then so those were all kind of issues related to student-on-student liability and student-on-student issues. There are also issues under Title IX of employee-student situations, and those are sort of the sexual harassment situations. And the hypothetical actually that is right before the sexual assault hypothetical addresses one of those situations. So why don't we take a couple of minutes and look through that when we talk about those issues. The facts that I've set forth here are actually pretty much exactly what happened in this situation. We had a student who was a work-study student, a freshman, was pre-med as much as any freshman could be pre-med at the time, and was working in the science building. And we had a faculty member who was emeritus at the time, had been at the institution literally for over 50 years, and was sort of known to be eccentric, was just a kind of an odd individual. He was a faculty member who had literally his whole life had been at this institution, was very devoted to the institution. When he retired, he donated a lot of money to create a research institute at the institution that bore his name. And he still conducted research for that institution in the science building, and so would interact with employees and students in that capacity, but wasn't teaching anymore. And the individual, the freshman, and this, I don't mean for this to sound sort of mean in any way, but it was something that was kind of important as it played out. This faculty member, emeritus professor, was shorter than I am, and he was this very small man. He was in his age, like 82. And the student was 6'2", he was this big, strong kid, a big guy. And that was important because, there wasn't any kind of physical intimidation. Friendly student could have killed this faculty member. He was just a big guy. And, so we had a situation where the faculty member, or the emeritus faculty member engaged in, it ended up being a total of 3 interactions that in total were less than a minute and a half long altogether over a period of a few weeks as the student first started in this position. And they were literally pretty much verbatim what you see here. This student had, frankly, very beautiful hair. I was jealous of his hair. This very kind of curly blonde hair. It was really beautiful. And the faculty member walked by and said, "You sure got some sexy hair. If you were a woman, I'd date you." And he kind of walked by and just smacks the kid on the butt and keeps on going. It was just a very odd interaction, and a couple of more things similar to that were just really bizarre, frankly. Really odd. So, the student first kind of mentions it to his supervisor, who is basically a lab tech, not a faculty member, not a high-up supervisor, but sort of oversees the student workers. And the guy's like, "Oh yeah, that's, crazy old Dr. Field, and do you want me to tell anyone about it?" And the kid says, "Nah, I'm okay." And the employee believed him. He said, this kid he didn't seem bothered by it. He was laughing. It was kind of funny. And then a few weeks later, they see each other in the hall, and this emeritus faculty member walks over to this guy who, at the time, the fashion that young people were wearing were sort of the low-cut, even men were wearing kind of the lower-cut jeans. And so I don't know why, but this kid had a little bit of exposed, he usually sees this on women, but he had a little bit of a midriff going. And the faculty member walks over and pinches his belly and kind of giggles and then walks up. It's bizarre, right? It's weird. And he tells his mother, and the mom gets really mad and starts calling people in the administration. And so at first, the first person they talk to says, who's the chair of the department, kind of says, well, I can't, he doesn't really work for me because he's this director of this institute, so I really can't do anything, but let me put you in touch with my boss, and that person can do something. So as soon as they talk to the person one step up, that guy, they sit down with the emeritus faculty member and they say, what's going on? He totally denies anything has happened. There are no witnesses to anything. And frankly, this guy is of an age where, and of a sort of mental state where you kind of wonder, would he remember? He may genuinely not remember doing this. And so they say you are not to have any interactions with students, you have to go through sexual harassment training, and they kind of put all these different requirements in place. And then there's one more interaction after that where something happens, the student comes in and they go to the faculty member and say, you cannot come on campus anymore. You cannot come back here, we cannot have you. We told you not to do anything, and you are now dealing. And they had tried, and there was actually sort of a progression where they had tried different things. They had sent him some letters, they had sat him down, and they just decided that you can't trust him anymore. So they said, you can't come back on campus. And I will tell you, to this faculty member, that was like his world ending, because this institution was his whole life. And he literally kind of just went between the institution and home. He was 82. And so he ended up coming back on campus a few times, and what would happen is they would sort of gently send him back home and say, you can't come anymore, we have to. It was a very sad situation. And actually what ended up happening is both the professor and the student sued the institution. The student was mad because he had come back on campus, and they said, you should have arrested him anytime he came back on campus. And the faculty member said, you should have never banned me from campus. And so it was one of those where nobody was happy, and it was very difficult to figure out what to do. But this was brought by the student as a Title IX claim, he brought it both as a Title VII claim, which is the federal statute dealing with employment discrimination, because he was a student worker, so he brought out an employment-based claim. Then he also brought a Title IX claim. And he said, this was sexual harassment of me, I was a student, the institution should have corrected it, there should have been something done more about it. And so one of the first things that we looked at was this sexual harassment? Was the actions that he alleged happened with the faculty member, were those sexual harassment? What do you guys think?
Yes.
Now remember, the definition of sexual harassment is harassment based on gender. It has to be, if I'm walking down excuse my language, I call this the same asshole to everyone defense. If I'm walking down the hallway punching both men and women in the arms, I'm not doing it because of their gender. I'm just a jerk. And that's not illegal, unfortunately. If I'm only punching women and I say, I'm hitting you or I'm harassing you, I'm smacking you because you're a woman, that's illegal because she's a woman. So here we have a faculty member who in the investigation does this to a male student, but we've learned he's done it to a female student. So is it sexual harassment?
Wait a minute. This makes no sense. Because
It's unwarranted, unwelcome, unsolicited, is that still part of the definition, or is that?
Unwelcome.
okay, what about like in the case of pedophiles, I'm not a counselor or whatever, but they don't have a gender specific, they abuse both young boys and girls.
Pedophilia, though, these are all different legal concepts. Pedophilia is illegal, is a criminal offense.
Okay.
And so pedophilia deals with the way you're relating to people under a certain age, and it's criminal to engage in behavior against individuals that are under a certain age. Discrimination statutes like Title IX or like Title VII protect against discrimination based on certain statuses. I can't discriminate against you because of your gender. I can't discriminate against you because of your age. I can't discriminate you because of your disability. But if I'm a jerk, and I'm a jerk to everybody, that's not illegal, because I'm not doing it because of your class. And so those issues of being a jerk to everyone, we now refer to as kind of bullying issues, and a lot of workplaces are dealing with those separately, but they don't violate Title IX, and they don't violate Title VII. They may violate what you want to happen in the workplace, and the employer may still address it, and they should address it, but it doesn't give rise to a lawsuit. And that's the distinction here. And so in this situation, one of the issues was the professor treating the student that way because of his gender? Because if it's not because of his gender, it doesn't violate Title IX. Kind of weird, right? So what do you guys think? Was this because of his gender? Should he have a sexual harassment claim in this context? What do you guys think?
He has pretty hair.
He does have pretty hair. It's sexy hair, is actually what the
There
professor
are
said.
so few.
So the way that his attorney, the argument they made that it was sexual harassment, and this gets really weird, okay, so stay with me here, was it's sexual harassment because this particular male didn't act like a typical male, like that he was sort of a little effeminate with his hair. So it was because of his gender, because he was kind of effeminate, and that's why he was being singled out. That was the argument that they made. I'm telling you, the law evolves. That's what I'm saying. It's crazy.
The law complicates.
So do you think, would you all say that he should have been able to bring a sexual harassment claim based on the facts that are alleged here?
It almost sounds like mom pushed him.
Mom was definitely a helicopter parent. It was their family situation was also, they had a lot of family things going on too. But mom was really pushing it, yeah. So what the court ends up deciding in this case, they didn't even decide the issue of whether or not it was sexual harassment. What they said was, even assuming, we're not going to even decide that issue, but what we are going to decide is that the university's response was appropriate. It was prompt and appropriate. They did what they should have done. And so this claim can't proceed because the institution intervened when they actually had knowledge. And even though they didn't arrest him, what they did was responsible and was appropriate, and that's enough. And that was decided by the trial court. It went up on appeal to the 7th Circuit, and the 7th Circuit actually ended up affirming that. And so the case went away. But this was a case where, the attorney for the student was trying to make some new law on the issue of the harassment, and the court ended up just punting that issue and not deciding it, and just saying we're going to focus on the institution's response. So that kind of shows you sort of how these issues can get a little bit crazy in situations.
So they did the professor then?
The professor also sued, and we defended the university both against the student claim and the university claim. We ended up winning at the trial court he brought 9 different types of claims alleging things like breach of contract, a whole bunch of other types of claims, and unfortunately what ended up happening is he actually ended up dying. And so the case went away because he had started to appeal it, but then he passed away. So it was a very, very sad situation. He had been a very integral part of the community, and I think when he was banned from campus, it was very sad. The whole thing was terrible. And it was a situation where both sides, both the professor and the student both really believed strongly what they were saying, and the university was trying to kind of balance the different interests at play and do the right thing, and there was no one who was going to be happy. So it was a very difficult situation.
What I take away from some of this, and both colleges have this, is when you have, because of the unusual status of the emeritus professor, we all use auxiliary service providers, food service or bookstores or lawn mowing or whatever, country for counseling. And so it really, I think, begs the question, what is our responsibility when somebody who is using the campus facilities but is not necessarily employed by the college, what responsibility does that put on us if something like this happens? If a food service worker makes an inappropriate comment to a student or a staff member, that doesn't negate your requirement to address it or demand it addressed, and that you run it through your process. The fact that they aren't your employee or your student doesn't free you of that, because I think, generally speaking, the courts would assume you've got contractual responsibility.
Right, and what a court would say there is, and what the student would assert, and they would have a good argument, is that the student is being exposed to that individual because they're on your campus. You are allowing that individual to be on your campus. And your remedies with regard to that individual are going to be different. Like, you can't discipline someone who's not your employee, but what you can do is I've reviewed a lot of contracts between like third-party vendors and institutions, and they almost always say, well, they're not our employees. This is the complaint process we go through. You agree that all your employees are going to comply with all legal requirements. And so the first thing you do is you get that complaint, you call that vendor and you say, you got to yank this, we've had this allegation. And that vendor should then do their own internal investigation. I had a college, I actually had that situation come up, I think it was 2 years ago, where I had a third-party food vendor on a college campus, a student alleged harassment, and we got the claim in, we kicked it over to the vendor, and they kicked it up to their lawyer, they did the investigation, they yanked that employee off campus because they were gonna face a claim by the students for some type of harassment. It was actually a student worker who was working in the cafeteria but under these vendors. And so they have the same incentive to deal with it, and they want to maintain a good relationship with the institution. And so, but you have to do something. You can't just say, oh, not our problem, and just ignore it. You have to do something about it. Yeah.
Do you ever see the employer student in that situation try to choose who to sue based on the idea of deep pockets?
Of course, yeah.
I mean, so how do you get around that legally and say you're suing the wrong person? Like, is that a quick decision, or does that take longer?
It depends on what the reason is. I mean, it really, if there's no legal basis, we would file what's called the motion to dismiss, where we would say there's no basis of liability. There's a theory of liability here that you can proceed on. And then the court, and nothing in the court system happens quickly. I mean, I have a case that it came in last fall. I looked at it and said, we're going to win because it was a Missouri Human Rights Act claim. The attorney who filed it didn't know what they were doing, and they filed after the 90 days had passed on the right to sue letter. But they had, anyway, this is way more information than you need. But I knew by looking at it immediately that there was a procedural basis they couldn't proceed. And so I filed a motion to dismiss, and it just kind of sits and sits and sits. And finally, literally last week on Wednesday, we had it set for hearing on Thursday. The other attorney called me and said, I read your brief. I know you're right, I'm going to dismiss my case. But that was like 9 months after I had, the case had started. So even though I knew from day one, this isn't going to go any further, it doesn't happen overnight. And that was someone who actually read my brief and was like, oh yeah, you're right. And I will tell you, that almost never happens. But, if the attorney had done that, we would have gone and argued it. The judge would have sat on it for maybe months, and we may just have been sitting there, and there's nothing that I can do as an attorney to make it go faster, even though I'm like, hello, I'm right, everyone knows I'm right. And that's very frustrating for the client, who's like, you're telling us, Kate, that this is going to go away. I'm like, it should. I just can't control when that's going to happen, and I can't guarantee the court is going to agree with me, even though I know I'm right.
And to your question about deep pockets, which is always an issue, but if you're able to put forth any question of law, then the court feels an obligation to address it. I mean, procedural things notwithstanding, you may not be in the end be decided, but the court will look at it as a matter of law, and it's not uncommon for everybody to be named in a suit,
Yeah.
even though you had nothing directly involved with it. It wouldn't be unusual for, if a student assault occurred, but they might sue the student, they might sue the student's family, they might sue the college, they might sue the president, just because they want to get access to that. And it's hard to simply dismiss it on the basis that it looks like you're going for deep pockets, because there might be a question of law there. So they'll at least want to pursue it before they dismiss it. So, and the kid on the other side, sometimes settlements are a lot easier and cheaper than it is to adjudicate.
Yeah, that's absolutely right. And that's a hard pill to swallow. Is sometimes we can say, we know we're right, we did the right thing, but if this process is going to take forever, it's going to take up time for the administrators or staff involved to deal with it. It's going to take up a lot of attorney's fees, and so we're just better off resolving the situation and walking away. And that's very, very difficult for people to understand, because they don't want that to be construed as people assuming they did something wrong because something was settled. So that's very difficult. All right, so that kind of goes to the issue of liability related to employee student type issues. We're coming up on 3. I'm not sure if you want me to keep going for a little while, or
We got started a little bit.
okay. So the next issue I wanted to talk about related to students are student accommodation issues. Section 504. All right. What is Section 504?
It's like a medical version of people that have a medical condition and have to be accommodated.
Right, so it is, exactly. So we have, how many of you have heard of the Americans with Disabilities Act? Okay, so 504 is actually an older statute that was enacted in the 1970s. It's the Rehabilitation Act of 1973, I think, 1974, but it's known as Section 504. And what it says is that basically recipients of federal funds or federal programs cannot discriminate on the basis of disability. And there are particular provisions that relate to higher education that say in the provision of educational services, you can't discriminate on the basis of disability. And so, and then we also have the Americans with Disabilities Act, and that relates to institutions of higher education in two basic ways. One, one issue is the employment issue. The ADA is what says we can't discriminate on the basis of disability under federal law in the employment context, but there's also a provision of the ADA that deals with public accommodations. And so, public institutions are considered to be public accommodations, and so therefore can't discriminate under the ADA as well against their students in the provision of educational services. So I will tell you, so the things that most people that, when I talk to 504 coordinators on campuses and folks in student services, most people know that 504 addresses some of the issues of things like extended testing time. There are some sort of basic, having a quiet room to do testing, maybe being able to take a test and do it from home. There are kind of these academic accommodations that people are used to now that deal more with learning disabilities and those types of situations. But what I'm seeing more of, and what folks don't seem to be as familiar with, are questions about kind of severe physical limitations, or maybe things like what we call non-visible disabilities, like OCD or anxiety issues and those types of things, and how we accommodate those types of issues, frankly, both on the employment side and on the student side. And so I actually got a call a couple of months ago from one of my community colleges that was dealing with a physical disability of a student who was very severely handicapped and was asking for an accommodation. She had an aide that had to be with her at all times, and I don't remember the medical condition, but it required her to, she had to have a tube in her neck at all times. And so part of this aide's responsibility was to clean that tube, and the accommodation she was requesting was access to a room where they could do that cleaning, a sterile room where she could do that. And I got the call, and the college said, what, do we have to give every student that calls us, or how does this work, how do we do this? And on all of these issues, the question becomes, what is reasonable? The point of 504 and ADA is to remove educational barriers. You don't have to change the requirements of your educational program, but the point is to remove educational barriers to allow the students to succeed where they might not otherwise. And the question always comes down to what is reasonable, what can we do? And so if you have 1,000 students asking you for a room, to make some changes, you're not going to have the space to do that. But if you have one student who's asking, or two students, you probably can find a room to do it. And so there's not sort of an easy yes or no. These questions, they're all individualized inquiries where you're trying to figure out what can you do under the circumstances with the resources you have that are available. And I see a huge variety in the way the campuses approach this. I had 2 campuses call me within a 6-month period about the same issue, and the way they approached it was so completely different. It was really interesting. In both cases, these were residential private colleges who had applicants come onto their campuses who were wheelchair bound. And so the first college called me and said, okay, we have an applicant who came onto our campus who's wheelchair bound, and we have an older campus, and the program that she's interested in meets on the 3rd floor of an old building that doesn't have an elevator. And they were like, what do we need to do? We don't have to, it's grandfathered in under ADA requirements in terms of having an elevator. What do we need to do to make sure that if the student is admitted, we can, get her into this educational program? And they had already contacted an ADA facilities person to try to figure out how they can make the building accessible to the student. And they had this whole plan, and we kind of talked about what is required, what should they do, da 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 da. I got a call 6 months later from another college who had the same thing come up. This is terrible, but the question I got was, well, we can't, what are we supposed to do with someone in a wheelchair? And I was like, well. it was just the contrast in how different places approach it. And it wasn't because that second college didn't want to, have someone in a wheelchair. It seemed so insurmountable to them. They just thought, there's just no way we can do this. And it was because they hadn't had to think about it before, and they just didn't realize that they have an obligation to think through. You can't just assume you can't do it, right? You have to think through, what can we do that's reasonable? And that's the biggest thing, is what can we do? And there are sometimes students ask for things that just seem so crazy because you've never had anyone ask for it before, but maybe you can do it, and you have to think about whether or not you can do it. And I can tell you, with the advent of IEPs, which don't apply in a higher education context, but most people don't know that and don't understand that. And so they say, well, my kid had an IEP in high school, why don't they have an IEP now? You say, well, if you tell them because the IDEA doesn't apply to higher ed, that's not a very satisfactory answer, which is actually the truth. And so a lot of colleges still call education plans IEPs because that's what people are used to hearing, but technically it doesn't apply. And so really what you're trying to do is you're trying to figure out, are there educational barriers you can remove to help these folks succeed? And I will say what I find to be one of the more difficult issues are when you're accommodating students who are in medically related fields, because the concern that comes up a lot is, depending on the nature of the student's problem, I've had institutions say to me, we don't want to graduate someone that has this problem because then they're out practicing in this medical field and it reflects on our institution, and if this person does something, terrible out in the medical field, what are we going to do? And so there's a case that we litigated, it's been several years now, that was under these ADA issues related to a medical student, and that is our next hypothetical. This is, and I know from talking to folks in admissions that it always sets off a red flag when you have a student who comes in and is arrogant to your admissions folks right off the bat. And I had one institution call me, and it was a certification program that was in the medical field, and the applicant was just very arrogant, and they were just like, we just don't want to admit him on that basis. Like, we don't want him to come in. And it was a community college that had an open enrollment policy, and this was a competitive program. The problem was this applicant had the highest scores of everyone who was applying. And so they didn't have, their admissions criteria said, if you meet X, Y, and Z, you'll be admitted. And so he met all those criteria. He was probably a jerk, but they just wanted to say, we don't want to deal with him anymore. And I had to say to them, well, have you talked to him about that? Or how have you tried to address that? Well, we don't want to talk to him. We don't want to put anything in his file. We just don't want to let him in. And, I had it come up twice, and in one case, admittedly, the guy was crazy, but he ended up suing them, and they didn't, when they were asked about why they didn't admit him, they didn't really have a good answer because they hadn't documented any of the issues. They had just kind of made a decision they weren't going to admit him because he was a jerk, but it was never documented, and no one ever talked to him about it. So he didn't know that was why. He just thought, you're discriminating against me because he had a known disability. And so he alleged disability discrimination, and it was hard to respond to that because we hadn't gone, the institution hadn't gone through any process. They had just decided not to let him in. And it maybe was the right decision ultimately, but it certainly was difficult to defend, and it really wasn't the best process to go through. But I say that to say, I think, we all have great respect and discretion for folks in admissions and the sixth sense they have about applicants and sort of knowing this person and maybe isn't a great fit for our institution. But when you have open enrollment, in the absence of criteria, and even if you have criteria related to the way people act, most of the time your criteria is just simply going to be, do you meet, do you have this GPA requirement, do you have this, this, and this, and that's the basis on which you're making the decision to admit the person, and that's it. So in this situation, this medical school certainly, there's certainly concern when you have an applicant who calls himself Dr. A Surgeon, that sends up a red flag right away that there may be some issues there. And also concerning when he wants to go into a psychiatric rotation because, you're probably thinking, yes, everyone who's teaching you can diagnose you as having many problems. But I think this case really, is a great demonstration of the issues that come up in the academic context related to disability accommodation issues. And what amazes me every time I reread this fact pattern is the length to which this university went to try to accommodate him. I mean, they kept giving him chance after chance after chance. And they were giving him a lot of opportunities to come back. And so, first, I guess wanted to ask you all what you all think about this issue of him not wanting to report to Dr. Lang at the end whenever, as part of his rotation. And what do you all think about the issue of having a student request as an accommodation, not having to report to a specific faculty member?
I think you can document that it's not an accommodation, and if you have a process before where students can say this person is more comfortable for me based on the professional relationship that we have, then it's okay, but I don't think that it's an accommodation at all that is required.
So if you said, what if you had a student say, I need a new advisor because my advisor really stresses me out and I have an anxiety disorder. And so by having this certain advisor, it creates an educational barrier for me because I get so worked up, I can't go talk to them about my issues. I want you to give me an accommodation and give me a different advisor.
Well, it depends on your office, but a lot of offices for advising, or if it's faculty advising, you have enough people to potentially switch to. So it's something that you just have in your process naturally of different people connect to different people better or more strongly, so it's a possibility. If it's one or two people and they have their set numbers, you can say, no, that's not an accommodation. This is who your instructor is going to be because we don't have any official claim that there was any discrimination. We feel like this professor helped and supported you and will continue doing so.
Do we want to accommodate someone who says, I'm so stressed out by interacting with this individual, you have to give me someone else to deal with? So like if a student says, I'm in this math class, but this faculty member is stressing me out, you need to transfer me to a different section and transfer all my academic credit to someone else. Is that a situation?
Much different situation. Well, my question would be is what is it that's stressing you out? And I mean, if you can verbalize, oh, she talks too fast, so she stresses me out. Well, then can you go back?
You're talking about me, aren't you?
No, sorry. That just came in my, I don't think you talk fast enough. I'm going. Oh, he wears this awful shade of blue and I can't look at the, if they can identify what it is that's causing the stress, then maybe you can work with the faculty member. I'm so sorry, I did not realize you were wearing a
You're
blue
just
shirt.
like,
Holy cow. But if a lot
How many of these supervisors were there? Was there even another supervisor?
There was another supervisor.
And it was just set standard that they were just assigned to somebody? Like, our students can enroll in classes, they can see who the instructor is gonna be a lot of times before, so if they don't like somebody, they can take a different instructor. Now, like, I teach a section or something that our business students have to graduate, and I am all they got. And I've had some of them 4 times. And I can teach, it's not that. But they don't have another option, so what if they start complaining about me and they're in Linda's office?
Just don't wear a blue shirt.
I know, yeah.
Well, I think, so what ends up happening in reality whenever and we don't thankfully get them that often, but when you get those requests to change, and you start thinking about it, a lot of times the faculty member, and advising isn't the greatest example because, as you point out, there are usually processes outside, almost always processes outside of 504 that you can use to change. And sometimes you don't even have a specific advisor assigned and the student can just kind of go into that office. But when it comes to faculty or supervision from maybe a mid-level administrator within an academic office, a lot of times the faculty member will just say, well, it's because I'm holding the student accountable and they don't like that I gave them a bad grade. And so it's sort of how do you separate out what the disability is from the student maybe isn't doing great in the class, and this is a sort of a defense mechanism to get into what they perceive as being a class that maybe is more easily graded. And that's a situation where institutions are very reluctant to make those kind of changes because they don't want to, I'll tell you the fact pattern I see, and I've seen it probably 4 times in the last 6 months, is it's a student who then wants a refund, like they want to get out of the class, they want a refund of their tuition, and then they want to go into another section that they perceive probably as being easier. And the institutions get, understandably are concerned, because they're like, if you get into a class and you don't like it, that's not a disability accommodation. You need to withdraw from the class, and we tell you at the outset what our tuition requirements are. And you pass the drop date, and we're not going to refund your money now because you didn't like the class. I mean, we have a process for that. And so it's those issues where you have to kind of think through what's really going on here. And it does make sense, I think it does make sense to sit down with a student and to say, okay, I hear what you're asking for, let's talk about why you're asking for it. And you go through with them and you kind of document the process you went through and the information you got from the student. And then that kind of helps you figure out and say, okay, you say, as you all pointed out, what is your concern with this faculty member? All right, you say that, you think he's a really hard grader. That's not a disability issue, and you kind of can then educate the student about really what the process is that's involved. But those situations can be really troublesome. And again, as I talked about earlier, I see it come up a lot in those medically related fields because institutions get very concerned about the perception that they are going to have to lower academic standards to allow a student to be successful. And the courts have said that accommodation issues are not met. You don't have to fundamentally alter the academic requirements of a course. That's kind of the standard for what you don't have to do. But what is a fundamental alteration? And that's one of those questions where the law is evolving all the time on what is a fundamental alteration. And I think we're going to see more and more of these cases and these issues coming up, again, as we have students on IEPs that have made their way, have been on IEP all through elementary school or are coming in through college and beyond, and they're going to just, expect for certain changes to be made once they get into the higher education context. And I think we've already, I'm sure all these student services folks see that a lot. The students come in with IEPs, so.
And then all said, you do occasionally have personality and people conflicts. And so while you might be within your rights not to make a change, you might also have to consider, is this in the long run in everybody's best interest? Because I have somebody else, or a different way I can address it, because I'm concerned that now it's become so personal or fractionalized that I just can't, there's not going to be a good resolution here.
That's a great point, and I thank you for saying that, Ray, because that raises another issue that I like to distinguish when those situations come up. There may be times where you decide this isn't an accommodation under 504, but we're still going to make a change because we think it's in everyone's best interest. And I think it's always really important to document why you're making the change and to make sure the student understands we are granting your request. We don't view this as a disability accommodation, because then the next time the student has something come up, they're going to say, you've already acknowledged that I have this disability and accommodated me this way, you need to do it again. And so it's important to say, in this particular circumstance, because of these particular issues, as an institution, we're gonna just go ahead and do this because we think it's the right thing to do, but we don't view this as a 504 accommodation, so that you're not setting that precedent down the line.
And you can even go so far as to acknowledge to the individual that we don't view this as a performance issue at work. This is just simply to try to resolve the issue. Not saying anybody feels good about it, but I mean, you really have to dot all your I's going down, but you might decide that's in the institution's best interest, because you can see the train wreck that's going to happen if you don't address it. And you have to put those binoculars on every once in a while. Look, where am I going to be ahead? Do I have choices, or I'm right on this, and but I'm going to be dead right, because when it happens, it'll be ugly.
Yeah, and then 504 issues and accommodation issues, and actually issues in other contexts, sometimes do create issues with your faculty, because the faculty say, what happens in my classroom, I control that. I control the curriculum. I control what's happening in my classroom. But sometimes federal laws are going to preempt what we put in place in the classroom, and the place this comes up a lot are like on attendance policies. So for, faculty typically set the attendance policy for their class, and they say their syllabus may say, you have this many no-fault absences. Once you go beyond this, you're an academic fail. And if you have a situation where you're accommodating a disability, you have to say as the institution, I know you have this faculty policy, but we also have federal requirements that we have to meet. And that can be something that faculty don't like or don't understand, and they oftentimes view that as sort of you're usurping their rights to control what happens in their classroom. And you always have to explain, no desire to do that, but the institution has to comply with federal law. I'll tell you the other place where this has gotten a lot of press within the last year and a lot of attention is the issue of pregnant students. Because, and I don't know, well, I don't know how many of you, this was actually in the news, but last summer, the OCR issued guidance about pregnant students, and pregnant students are covered by Title IX. Title IX, the regulations related to Title IX say that the gender discrimination prohibitions related to educational services also extend to pregnant students. And it says that you cannot discriminate against pregnant students in the provision of services, and that would include, it includes sort of any of the educational opportunities that are related to that. And one of the things the regulations say specifically is that if you have leave policies, you have to treat pregnancy-related leave the same way you treat any other type of short-term disability. And they actually say if you don't have student leave policies, you have to excuse any pregnancy-related leave that is deemed to be medically necessary by the student's physician. So what that means is if you have and actually the regulations go on to say, at the end of the leave, you have to reinstate the student to the same place they would have been if they had not gone on leave. And I will tell you, in the context of higher education, what does that mean? How do you reinstate a student who goes out halfway through the semester, right? And so that becomes very difficult. And I became very familiar with all of this because I represented Logan University in the last year. They had a complaint under pregnancy discrimination. It was in the paper, and I worked with them to resolve that complaint. And they were unfortunately sort of on this wave of increased enforcement that's going on right now. There is also an initiative by a group called the National Women's Law Center, and what they've been doing is going around and they've been finding situations at institutions where students are complaining about pregnancy discrimination, and then they represent the students and go to the OCR, and then they show up at the institution and say, you have to adopt our policy language to resolve this complaint. And they have done that about probably around 5 or 6 different institutions now, and they kind of add in a little bit to the policy each time. And so they show up at your doorstep and say, well, this institution's already adopted this policy, and so you should adopt it too. And if you don't adopt it, we're not gonna, this complaint's gonna go forward and we're gonna file a lawsuit. And so, and I will say I have a lot of respect for the National Women's Law Center. It is a great goal to try to eliminate pregnancy discrimination and equality for women in higher education and for men, for everybody on the basis of gender. But what's hard about it is that you don't ever want to have to adopt a policy and down the barrel of a gun. You want to have time to kind of think down through your processes and figure out what makes sense for your institution. And in Logan's situation, they have, it's a chiropractic college, and so their students have to do a lot of clinical work. And it is very hard to figure out how absences work in the context of clinical work. And so they, the National Women's Law Center was, pushing this language that just said, you'll be reinstated, and they kept going, what does that mean? Like, if you're halfway through the clinical session and you drop out, we're not just going to pass you. You have to complete the clinical requirements. And so that's one of those issues that becomes difficult, and the law isn't always adapted to the particular circumstances of your particular institution and your educational requirements. But it's also a situation where if there are those pregnancy-related absences that are deemed medically necessary, those can't count against the student, and you can't turn it into an academic fail if they miss more than the absences that are allowed for in the syllabus. And faculty have to understand that so that they know not to count those as absences when they are medically necessary. So another issue that has gotten a lot of attention recently and that people are seeing, and the National Women's Law Center is doing a good job of creating publicity and encouraging pregnant students to file complaints and go to their institutions. And so I've actually gotten a couple of calls from other community colleges about how do we accommodate pregnant students. And it's something to think about, before you get the question, or to at least make sure that your folks know that it's a big deal, so that if the question comes in, it gets kicked up to the right person to help figure it out.
Where does the idea of reasonableness come in with that? Because that's the big key word with any 504 is the change has to be reasonable. So is that the faculty's obligation to set what is reasonable for my course, or is that going to be, you think, higher up for departments or board for the whole college? Because I could see that being different for each class or study of education or field or major.
I like for there to be, the 504 coordinator should be involved in those decisions, because if it's just left at a faculty or even a department level, you're going to have different people doing different things within the same institution. So you're going to have a student who's in one class and the faculty member may say, don't worry about it, and then they go to another class because there's no sort of centralized communication about how it's being handled. So actually under the pregnancy stuff, technically the Title IX coordinator should be involved in that because it's a Title IX issue. But in a lot of times the Title IX and 504 coordinators are the same person at smaller institutions. But you want to have someone that's at that coordinator level involved in those decisions so they can help figure out what is reason. They can say, I can take a college-wide view of this issue and really kind of figure out what's reasonable. And what is reasonable ultimately, if there's a dispute about that, is going to be decided by a court.
And from my standpoint, I also want somebody who has some authority to work with other departments. Because keep in mind, in addition to the personnel and personal issue we're talking about, you could be talking about some other kinds of accommodations that require, physical changes to an environment or something like that. So it has to be somebody who can, by the nature of their position, say, we need to bring building and grounds into this, or, what, I need to think about, what, if there's a physical change that has to occur, or, is there something that the college can accommodate in a different way? And so you've got to have somebody who's got the ability to make at least a reasonable amount of decisions, or at least have contact with people who do. And I will add, while I'm rolling down that track, you also then have to look at the state statutes. And, just recently we had a legislator out of University City pass away, but right before he did, he got the governor to sign off on his family law bill, Roy Ellinger. And that extends rights to new parents. Okay, so now Missouri's going to change a little bit and become more progressive in terms of what you might have to provide, a new mother. Well, all of these things as it evolves keep coming into, then who gets to decide? Can you identify a room where a breastfeeding mother can express milk? Who's got the authority?
Right.
Yeah.
And that's a requirement under the Fair Labor Standards Act.
Right, yeah. So, but you've got to have somebody who can make that decision and decide what's going to be reasonable based on the knowledge of facilities, not just on the personal, wow, that closet will work great. You got to.
Yeah, these issues become, and that part of, why I wanted to talk about these issues to this particular audience is that these are cross-campus issues. And they are very hard to decide in a vacuum, and you really have to involve all different stakeholders in the decision-making process because everyone brings different types of knowledge and information to the decision-making process. So I think we've gone probably.
Yeah, and I'm going to add just one little asterisk, just because it comes into play. Sometimes you can push the issue up to a different level. I'll just give you a quick example. At my last college, I had a student who had, at a very young age, received drug convictions. Qualified for a nursing program, went through, and then the drug convictions we became aware of them. But we didn't prohibit the student from going through the nursing program because of those drug convictions. However, we had to tell the student, we can't promise you that you will be allowed to sit for the state exam. And in fact, put it in writing. And so when time came, of course, a couple of years after you tell the student that, and they go to sit for the state board, and they're not allowed, of course, and they turn back on us. And we had to demonstrate that we had counseled the student that we will provide you the education as we are required to do. And we even had to make certain clinical accommodations because the student was not going to be allowed to do certain. Some couple of hospitals wouldn't accept her with these drug convictions, but she was not allowed to sit for the state board. So we took that problem and we pushed it to a different level because our original knee-jerk reaction of our nursing director was, well, she can't qualify anyway, why take up the seat? Slow down, let's take a look at what we can do. That's not our call. We don't decide who sits for the state board except for qualified applicants. That's going to be the individual's decision.
And that's a great point. And actually, that story actually brings up sort of what I feel like I always have to say as a lawyer, and you gave me a great example there, and that is the documentation issue. And I know whenever there is a legal issue and it gets kicked over to me, and I'm always going to say to the institution, what kind of documentation do you have? And I always get the inevitable, really, I don't have enough to do, Kate. And I'm like, I'm not doing this for me, folks. I'm doing it to try to make sure I can defend the institution. And Ray's point about documenting what was told to that student, because even though I just did a mediation on Tuesday where I was 12-hour day where I got something resolved, and the institution I was representing kept saying, well, we told this person, we told them, and I said, where is it in writing? Because she says you didn't tell her. Where did we tell her in writing? Well, she knows, she's just, yeah, but we can't prove you did tell her. So let's send an email. We had this conversation, let's send a follow-up email saying, this is to confirm our conversation, da 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 da. And you know what, that serves a lot of different purposes. First of all, I can tell you right now that each of you will remember something different about what I've talked about today or what we've talked about together. Because that's just human nature. We all hear things differently, we filter them through our own personal experiences, and we don't hear things the same way. And it may not be intentional that the person you're talking to doesn't remember what you told them. They may just not have heard it. And so when you send that follow-up documentation, it helps to make sure that you're on the same page, and that's really the most important purpose. But the second purpose is that later if there's a dispute about what was said, you have documentation showing that you actually told the person what you say you told them. And that is incredibly important in the situation Ray talked about, especially important on those 504 issues, any type of accommodation issue, super important on those Title IX issues, and making sure you're documenting how you responded and what the student told you and how you responded to what the student told you. But, we always, pretty much in every presentation, I always say document, document, document. Any lawyer gives a presentation says that, and it really is meant to protect folks and help everybody out. Yeah.
We, in the admissions department at MAC, when students answer the question about yes, they have a felony or no, they do not, we have a committee that goes through for a criminal like a background investigation, basically. And there are 4 criteria that we look at. If they meet one of those 4, we will deny them for, some of them are denied totally. Others are denied based upon maybe a year they just got out of prison or whatever, like to give them some time to prove that they can be a respectful citizen or whatever the verbiage is. So we send notifications to those people, but in the past we've had a student show back up on campus saying they never received that notification. We show we've mailed a letter. We show we've also emailed that student to their Mineral Area College email address. Is that sufficient? I mean, should it be certified in situations like that?
Certified mail actually doesn't do you a whole lot of good because people just don't sign for it.
Sure.
And so if you send it by email, I mean, you can, if you do send it certified, I always send it regular mail too because there's a presumption that mail is delivered. So if you're sending it to an email address that you know that they have received the email on in the past, and you can kind of print out that, that sort of electronic notification showing email received, and then you have, I always keep a copy of the letter you sent and indicate how you sent it. There may later be a dispute and you may argue about whether or not they received it, but you've done all you can do to show.
That's what I wondered, is
Yeah.
that we're doing all we know we can do at that point, but
There's only
we
so much
just-
to do.
we've had students say, well, I didn't get that. Or it goes to their home and they didn't really get it because their mom got it, or what, how do you?
And you always, and I'm sure, you all have policies that talk about people needing to update their contact information. And so if you're sending it to the most recent contact information you have, it's then, if their address changed or their mom did it up, that's not your fault because you sent it, you're documenting that you sent it to the best information you had. You've gone through the right, appropriate steps to do that. And then it's also, they're also, you hope that if the student didn't get it, they would call and ask the question. And then you kind of document the conversation you have. And if the student comes to you that initial time and says, well, I didn't get the letter, you say, well, I would always say, well, I'm really sorry to hear that. Let me give you a copy of what was sent. And then you make a notation that you did that. And there's only so much you can do.
Right.
We have students move all the time, and the real key is, and I had somebody tell me this once, document everything like you would documenting you paid a bill with cash. That you not only put it in writing so you have that in collection, but you also make sure that the right people are copied on it. And if you sent something out, you denote on your copy how it was sent. Because that will give you greater credibility. It may not stop you from having the argument, but it gives you that credibility. And believe it or not, occasionally we forget things. And so it really helps us to go, well, according to my records here, I did email you on April 24th. And we mailed it out on the 25th. And we never got it back. You can have that kind of record which moves that assumption or burden from you to the next person. Now, if you later discover they've moved 4 times, at some point you got to be reasonable. Somebody moves and doesn't leave a forwarding address, it makes it very hard for you to deliver on your promise to deliver something in writing. But you'll have to get to that point to demonstrate it. But whether it's a disciplinary action or simply an explanation, like Kate was saying earlier about, hey, we're going to help you, take out in this class situation, put it in a file somewhere. You might very well need it. And in this day and age where you can do it, or you can do all those records retention electronically, it's not a big burden. And in fact, it's very easy now to find and retrieve that kind of information in such a way that it's easy for you to get in the habit of storing.
Yeah, that's right. So I've got some other materials I've prepared, but I think this is probably a good stopping point for today. So I appreciate everyone's participation and hopefully you all to take something away from this more than that I talk fast and that I'm wearing blue.
Well, to quote Monty Python, my brain hurts. But I want you to know that I mean, this is just a very thin slice of some of the issues that come up. But we wanted to give you a flavor of what some of the issues are and why do we rely on attorneys so much. We just heard some very good reasons in a very narrow field of what's a very broad application in higher education. So it gives you a sense that you do over time become, you know, my law school was hard knocks. You know, I mean, you learn along the way because you have to. You end up being involved, and so, you know, when you work with your legal counsel, you always need to know that they are offering advice, but you know, you really got to have quite a burden if you don't take their advice.
I'm going to document that you said that right.
Yeah, write that down because I'll tell her no, but she usually talks me out of it. So. Well, let's thank Kate, shall we? Appreciate it.